Today I am going to deal with the Maratha Reservation Judgment delivered by the Constitutional Bench of the Supreme Court on 5th May 2021. The judgment is delivered by 5 judges of the Supreme Court in a very important matter relating to the 2018 SEBC Act passed by the Maharashtra Legislature, providing for 16% reservation to the Marathas in the state of Maharashtra. The Supreme Court held the 2018 SEBC Act to be ultra-vires and violative of the principle of law laid down by the 9-judge bench of the Supreme Court in the judgment of Indra Sawhney versus Union of India in the year 1992. This matter also dealt with the interpretation of the 102nd Constitutional Amendment, and that is also a very important feature of this judgment. The Supreme Court, in a 3:2 majority, held that the state is denuded of its power to identify the SEBC community in the state, and the power is now with the President to declare a notification providing for the SEBC, and only the President can come out with a notification. The states cannot declare any community to be a socially and educationally backward community. So therefore, this is a very important judgment. Now let us look at the facts of this case. The Marathas are a predominantly Hindu community residing in the state of Maharashtra. Now 3 national commissions and 3 state commissions till 2008 had held that the Marathas do not belong to the backward community. Rather, they are a forward Hindu community. They are a dominating class and also are adequately represented in the public service as well as in the political arena. In 1992, the Supreme Court laid down with a very important judgment in the matter of Indra Sawhney versus Union of India, wherein the 9 judges of the Supreme Court in its majority judgment held that the reservation cannot exceed 50%, and in order to exceed the 50% benchmark, the state has to show or make out an extraordinary case where the communities are entitled to a reservation of more than 50%. Now in 2014, the state of Maharashtra constituted a special committee to look into the matter of the Marathas. In 2014, the Rane committee recommended that the Marathas are entitled and should be given reservation in educational institutions and government service. Subsequently, the Maharashtra government issued an ordinance of 2014 providing for 16% reservation to the Marathas in educational institutions and government service. Now this ordinance was challenged before the Bombay High Court, and the Bombay High Court stayed the implementation of this ordinance. Now despite the pendency of this petition, the Maharashtra Legislature passed an Act of 2015 granting 16% reservation to the Marathas. Now this Act was again challenged before the Bombay High Court, and the Bombay High Court granted stay against the implementation of this Act. Now despite the pendency of these petitions, in 2017, the Maharashtra government set up a special committee comprising of Justice Gaikwad in order to look into the grievance of the Marathas. Before the Gaikwad committee could report, in 2018 an important development occurs when the Constitution is amended by way of an 102nd Constitutional Amendment, which inserts Article 338B, 342A and Article 366 Clause 26C. Now a new commission for the socially and educationally backward class is set up by way of Article 338B. Similarly, Article 342A provides that only the President, in consultation with the Governor of the state, can come out with a notification determining the socially and educationally backward communities. Now this is similar to Article 342 and also similar to Article 338, which provides for the Commission of Scheduled Caste and Scheduled Tribe, wherein only the President is entitled to come out with a notification prescribing for the Scheduled Caste and Scheduled Tribes in India. Now after the commencement of this constitutional amendment in 2018, the Gaikwad committee suggests 16% reservation for the Maratha community, as it holds that 80 to 85% of the population of the state of Maharashtra is backward, and therefore 50% of reservation for the 80 or 85% of population is unjust and arbitrary and is not in consonance with the principles of equality enshrined in Article 14, 15 and 16. And therefore the Gaikwad committee suggests an extraordinary case is made out in order to exceed the 50% reservation limit prescribed by the judgment of Indra Sawhney. Subsequent to this Gaikwad committee report, the Maharashtra Legislature annexed the SEBC Act of 2018, providing for 16% reservation to the Marathas in educational institutions and also in government service. So petitions were filed before the Bombay High Court challenging the validity of this act. The Bombay High Court upholds the validity of this act and also accepts the Gaikwad report, holding that special circumstances or extraordinary cases made out by the state of Maharashtra. Now this judgment is challenged before the Supreme Court, and therefore the Supreme Court delivers this landmark judgment constituting a 5-judge bench of the Supreme Court to decide on important issues of constitutional law. The question involved the validity of the 102nd Constitutional Amendment Act, as some of the petitions challenged this constitutional amendment as being violative of the basic structure of the Constitution. The state of Maharashtra argued that the judgment of Indra Sawhney is incoherent, and only 4 judges out of 9 hold that 50% reservation cannot be breached, and therefore that is not the majority view of the judgment. So the Supreme Court analyzes this judgment by framing the first question as to whether judgment of Indra Sawhney versus Union of India needs to be referred to the larger bench. The Supreme Court carefully analyzes the entire judgment of Indra Sawhney and holds that 7 out of 9 judges concurred that there exists a quantitative limit on reservation spelled out at 50%. Justice B.P. Jeevan Reddy for himself and 3 judges held in para 809 that the reservation contemplated in clause 4 of article 16 should not exceed 50%. Justice Thonman, Justice Kuldeep Singh and Justice Sahai, in their separate opinions, held that reservation under article 16 clause 4 should not exceed 50%. So therefore 7 judges held that the reservation cannot exceed 50%. Thus the Supreme Court holds in this judgment that the greatest common measure of agreement in 6 separate judgments delivered in Indra Sawhney is that the reservation under Article 16(4) should not exceed 50%, and for exceeding reservation beyond 50%, extraordinary circumstances as indicated in para 810 of the judgment of Justice Jeevan Reddy should exist, for which extreme caution is to be exercised. Now the Supreme Court holds that this is the ratio of this judgment, and the Indra Sawhney decides that reservation cannot exceed 50%. Now the reason for not exceeding or for providing this 50% benchmark is not a judge-made law or a judicial overreach, because what the Supreme Court holds in this judgment is that in M. Nagaraj versus Union of India, the Supreme Court observed that a numerical benchmark is the surest immunity against charges of discrimination. To dilute the 50% benchmark further would be to effectively destroy the guarantee of equality, especially the right not to be discriminated against on the grounds of caste provided under Article 15 Clause 1 and 16 Clause 1. Therefore, the 50% rule spoken in Balaji and affirmed in Indra Sawhney is to fulfill the objective of equality as engrafted in Article 14, of which Articles 15 and 16 are facets. The Indra Sawhney itself gives answer to the question. In para 807 of the judgment, the Supreme Court held that what is more reasonable than to say that reservation under clause 4 shall not exceed 50% of the appointment. 50% has been said to be reasonable, and it is to attain the objective of equality. The Supreme Court in this judgment also notices the speech of Dr. Ambedkar in the Constituent Assembly debates, which was delivered on 30th November 1948 while debating Article 16 Clause 4 of the Constitution. Dr. Ambedkar gave an illustration which said that supposing, for instance, a reservation were made for a community or a collection of communities, the total of which came to something like 70% of the total post under the state and only 30% are retained as the unreserved. Could anybody say that the reservation of 30% as open to general competition would be satisfactory from the point of view of giving effect to the first principle, namely that there shall be equality of opportunity? It cannot be in my judgment. Therefore, the seats to be reserved, if the reservation is to be consistent with subclause 1 of Article 15 and 16, must be confined to a minority of seats. It is then only that the first principle could find its place in the Constitution and effective in operation. Thus, the Constituent Assembly itself answers that the reason for providing the reservation cannot exceed 50%, and it has to be the minority of the seats which has to be reserved, and therefore also it cannot exceed 50%. Also, Dr. Ambedkar himself, who is the founding father of this constitution, suggested that reservation should not exceed 50%. And therefore the Supreme Court in this judgment held that the reservation should not exceed 50%, which has been held by Indra Sawhney, is the correct proposition of law. Considering all the arguments on both the sides, all 5 judges unanimously hold that there is no need to review the judgment of Indra Sawhney. Now, how this judgment can affect the 103rd constitutional amendment is a different matter. The Supreme Court did not enter into this issue, as the said petitions are already pending before the Supreme Court. The next 2 questions which were dealt by the Supreme Court were whether Maharashtra State SEBC Act of 2018 providing reservation for Maratha community in addition to 50% social reservation is covered by exceptional circumstances as contemplated by Constitution Bench in Indra Sawhney's judgment, and whether the Maharashtra State Backward Commission report chaired by MC Gaikwad has made out a case of existence of extraordinary situation and exceptional circumstances in the state to fall within the exception carved out in the judgment of Indra Sawhney. The Supreme Court holds that the main reason for the Gaikwad Committee to provide for reservation is that 80 to 85% of the population in the state of Maharashtra is backward, and therefore 50% reservation is not justified and is not in consonance with the principle of equality. The Supreme Court, by analyzing the constitutional debates and the illustration given by Dr. Ambedkar himself, and also the proposition laid down by Indra Sawhney and several other judgments which provided for 50% as the limit, and the exception which is carved out being extraordinary case is not met with respect to the grounds given by MC Gaikwad. So the Supreme Court holds that the Constituent Assembly, by giving the illustration, has already disapproved the principle which is now propounded by the committee, and therefore the Supreme Court cannot approve the view of the committee as well as of the High Court, and therefore the Act of 2018 violates the principle of equality as enshrined under Article 16, and the exceeding of ceiling limit without there being any exceptional circumstances clearly violates Article 14 and 16 of the Constitution, which makes the enactment ultra vires. The Supreme Court also observes that from the committee report of Gaikwad, the Maratha community has adequate and sufficient representation in the public service. Also, around 30% of the posts in state cadres are filled by the Maratha from the open category, and therefore if they can compete with the open category, then there is no question of reservation of the Marathas as being backward communities. The Maratha community are adequately represented, and that is what is held by the Supreme Court. The Supreme Court also observes that the Marathas are dominant forward class and are in the mainstream of national life, and therefore their situation is not an extraordinary situation contemplated by Indra Sawhney judgment, and both Commission and the High Court fell in error of accepting the above circumstances as extraordinary circumstances for exceeding the 50% limit. Therefore, the Supreme Court ultimately holds the Act to be ultra vires. With regards to the 4th and 5th question, which were whether the Constitution 102nd Amendment deprives the state legislature of its power to enact a legislation determining the socially and economically backward classes and conferring the benefits on the said community under its enabling power, and whether state's power to legislate in relation to any backward class under Article 15 Clause 4 and 16 Clause 4 is taken away or abridged by Article 342A, read with Article 342A of the Constitution of India. With regards to question 4 and 5, there are divergent views of Justice Ashok Bhushan with Justice Abdul Nazir and Justice Ravindra Bhatt along with Justice Nageshwar Rao and Justice Hemant Gupta. Justice Bhushan and Justice Abdul Nazir hold that the constitutional amendment does not take away the power of the state to identify backward classes in the state. However, Justice Ravindra Bhatt, Justice Nageshwar Rao and Justice Hemant Gupta differed from the view of Justice Ashok Bhushan, and Justice Ravindra Bhatt in its judgment holds that by introduction of Article 366, 26C and 342A, The President alone, to the exclusion of all other authorities, is empowered to identify SEBCs and include them in a list to be published under Article 342A. In the task of identification of SEBCs, the President shall be guided by the Commission set up under Article 338B. Its advice shall also be sought by the state in regard to policies that might be framed by it. If the Commission prepares a report concerning matters of identification, such a report has to be shared with the state government, which is bound to deal with it in accordance with provisions of Article 338B. However, the final determination culminates in the exercise undertaken by the President. The Commission set up under Article 338B shall conclude its task expeditiously and make its recommendations, after considering which the President shall expeditiously publish the notification containing the list of SEBCs in relation to states and union territories for the purpose of this Constitution. With regards to the question number 6, whether Article 342A of the Constitution abrogates states' power to legislate or classify in respect of any backward class of citizens, and thereby affects the federal policy structure of the Constitution. With regards to this question, the majority is of the opinion that the power of identification of SEBC hitherto exercised by the state and now shifted to the domain of the President by virtue of Article 342A does not in any manner violate the essential features or basic structure of the Constitution. The 102nd Amendment is also not contrary to or violative of proviso to Article 368(2) of the Constitution of India. And this is how the Supreme Court decided these 6 issues which were dealt before it. Whether this judgment will effect the challenge to the 103rd Constitutional Amendment, which provides for 10% reservation to the economically weaker section, is a question that will be decided by the Supreme Court in the coming days. But so far as the law laid down by Indra Sawhney, the Supreme Court holds that it does not require to be reconsidered or to have a relook. So therefore, this will have an interesting impact on the 103rd Constitutional Amendment.